I rise to speak in opposition of the Summary Offences and Other Legislation Amendment Public Assemblies Bill 2025. And Speaker, in doing so, it is important to place this bill in its proper context. Many of the measures proposed by the opposition are not new. In fact, most of them were previously moved as amendments to the Terrorism and Other Legislation Amendment Act 2025 and were voted down by this Parliament. The government's position has not changed, and for good reason. This bill seeks to amend the Summary Offences Act 1988 and the Law Enforcement Powers and Responsibilities Act 2002, commonly known as LEPRA. While it is framed as enhancing public safety, the reality of this bill is that it risks undermining community safety, burdening lawful protest and exposing the state to serious legal and constitutional risk. First, I turn to the proposal to introduce mandatory factors for police and courts to consider when determining applications for public assemblies. The current legislative scheme deliberately does not prescribe a rigid checklist of factors. That is not an omission, it is in fact a strength. It allows police and the courts to exercise broad discretion and to take into account all relevant considerations and to disregard irrelevant ones based on the unique circumstances of each particular assembly. By contrast, the opposition's proposal would require every listed factor to be considered in every case, regardless of whether it is relevant or not. This would make the process more complex, more time-consuming, and more burdensome for both those that are organising and the police themselves. There is also a very real risk that the organisers simply would not be able to provide information addressing every prescribed factor. Rather than improving cooperation, this proposal could discourage organisers from engaging with the police at all. That would deprive police of the opportunity to work constructively with organisers and to ensure assemblies are safe, well managed and minimise disruption to the broader community. Ironically, that outcome would likely require police to deploy more resources to manage unnotified assemblies, increasing disruption and risk rather than reducing it. The second major element of this bill is the proposed user pays model for repeat public assemblies. Once again, this proposal risks pushing organisers away from cooperation with our police. Policing public assemblies is fundamentally about public order and public safety. Introducing a user pay model does nothing to enhance safety and may in fact diminish it by discouraging lawful engagement with the statutory process. There is also a serious constitutional concern. A user pays regime of this kind could potentially burden the implied freedom of political communication. This is not a theoretical risk, Mr. Speaker. It is a real and substantial one. It is also telling that, to our knowledge, no other jurisdiction has adopted such a model. The absence of comparable schemes elsewhere speaks volumes about the risks of this inherent in this approach. I now turn to the proposed ban on face coverings at police assemblies. This amendment is unnecessary. In December last year, this Parliament passed the Terrorism and Other Legislation Amendment Act 2025, which already strengthened police powers in this area. Under Section 19A of LEPRA, police may require a person to remove a face covering if they reasonably suspect that the person may have committed or is likely to commit an offence. Failure to comply without special justification is already an offence carrying significant penalties. This is a targeted, proportionate and workable power that is grounded in reasonable suspicion of criminal behaviour. By contrast, the opposition's proposal imposes a blanket prohibition with no link to suspected criminal activity. It provides no clear thresholds, safeguards or proportionality. It does not adequately account for legitimate reasons people may be wearing face coverings, such as medical reasons. This lack of nuance and proportionality creates significant legal risk and again raises the prospect of improperly burdening the implied freedom of political communication. Finally, I address the proposed amendment relating to move-on directions. The provision the opposition seeks to amend has already been repealed by the Law Enforcement Powers and Responsibilities Amendment, Places of Worship Act 2025. This repeal responded directly to the Supreme Court's decision in Lees v State of New South Wales. As such, the opposition's proposal is no longer valid. Even if it were, it would not have addressed the Supreme Court's concerns. Police would still have been authorised to issue move-on directions in circumstances inconsistent with that decision. In conclusion, the government's approach is abundantly clear. We support the right to lawful assembly and political expression, while ensuring police have targeted, proportionate powers to protect community safety and prevent criminal activity. This bill, in fact, fails to strike that balance. It is unnecessary, it is unworkable, and it is legally risky. And it's for those reasons, Mr. Speaker, that I cannot support this bill.